Host, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors.
Welcome to the Ask the Experts Show with local experts in the fields of legal, health, financial, and home improvement. Enjoy being educated in such topics as personal injury law, community association law, family law, bankruptcy law, along with health show topics like pain management, men's health, and dental implants. Now, sit back and enjoy today's Ask the Experts with host Steve-O.
And it is the first Thursday of the month, and I am Rhonda Hines, joined by Robert Kay from Kay Bender Rembaum, and he is our expert in community association property law. So, how are you doing tonight?
I'm doing well. How about yourself?
Yeah, thank you. Thank you for coming out. I'm really excited about tonight because I feel like I'm going to learn a lot about HOA rules and regulations and what I'm getting into when I actually buy a home in an HOA community.
Well, it's hard to find a place in South Florida or even all of Florida where there isn't some form of mandatory association that's going to make you live by the rules.
Right. And do you feel that has become too much of life invasion, or do you feel like it's still beneficial to keep property, values high? What's your opinion on that?
Well, I think communities that have the mandatory associations have experienced the maintaining of their property values better than those that don't. Mm-hmm. And you see that anything goes in communities that do not have the type of mandatory associations, and the properties can become run down without anybody doing anything to make them be brought back up to speed. Where you have the associations, the people tend to be a little more diligent as to what's going on. You buy there knowing what the rules are, so it isn't like a surprise to you. It shouldn't be a surprise to you when you get there. So that's been my experience so far.
So, okay. Well, do you hear stories from clients who say, gosh, I started with the rules being one way, and then it just kept piling up, and then it became more kind of life control versus keeping my property value high? Do you ever experience that?
We have seen places where people express that is the way that it is, but different communities have different standards. So you have to be sure of where you're going when you get there. And if things change dramatically once you're there, part of that, I think, belongs on the shoulders of the individual owners, because it can't happen by itself. There is a board of directors in place that is elected or put in place by the owners, so they're representing the interests of their constituents, and they will be following the will of the people, or should be. If they don't, then the owners have the ability to replace them with people of more like mind to themselves in the political process.
Makes sense, right?
Should, in theory anyway. In practice, sometimes it doesn't, because there's a lot of apathy. You don't get enough people voting, so then you can't get a block enough to make the change that you need, and then you can find yourself stuck.
And then they only get angry after the rule's been changed and they didn't take their vote, their vote, right?
Yes, I've had people come and approach me in a situation where the last guy I was talking to, he's in a cooperative, which is an unusual type of home these days, and he said that the place had been taken over by 80% by people who live out of country. And they're holding board meetings in another country, and they're changing all these things, and what can you do?
That's odd, isn't it?
Yeah, well, when 80% are going one way, you're pretty much stuck. So your option becomes more like put your place up for sale and find a place that's more in line with your thinking.
But that can be challenging as well.
It is a challenge, yes.
Because
there's no perfect answer to some of these situations.
Now, you're a senior partner in a successful law firm. Tell us, what are some of the things the issues that you handle and what your specialties are?
Well, Kay Bender Rembaum has been continuously providing services to community associations in South Florida since 1992. We now
you're experienced?
Yeah, we've got some experience. Well, we have a large percentage of our attorneys that are now board certified by the Florida Bar in a recently adopted certification since 2018. And I'm one of them. So we call ourselves specialists because the bar says we can.
What kind of certifications are you referring to?
from the Florida Bar to certify us in this area of law that we practice in. And it takes a number of years of experience plus a number of years of continuing education plus passing of a test. So, and then ongoing education afterwards to maintain the status as certified.
Because the rules and regulations are constantly changing and you have to stay abreast of what's going on in the...
Well, in most areas of the law, it is that way. And certainly in community association field, it's that way in Florida. The statutes are usually changed every year in some way, if not every year, almost every year. There's regularly case laws that are coming out that are changing the way things operate. Plus, there are other things at play, like federal laws with fair housing and things of that nature. So,
Anything significant that's changed with fair housing recently?
actually, yes. HUD has come out with a new set of guidelines just last week that involve the emotional support animal issue, which is a big issue in the arena, with particularly in no-pet communities where people get around it by using emotional support animals as their basis to do so. And it has been a free-for-all for a while, and HUD has their tendency is more to protect the individual than the association. So the rules are skewed to allow for this type of thing. And there has been a lot of abuse in the area, people that don't really need it and don't really qualify for it, but they're able to get this minimal standard met from a qualified medical provider that says they suffer from anxiety and it affects their ability to sleep, so they need this little dog to keep them company, even though they're in a place that doesn't allow pets. Now, under fair housing laws, a support animal is not a pet; it's a medical assistant. So they would get around that restriction, and then you have to allow it. And the dog cannot be a nuisance to other people, a real nuisance, so you can have rules that limit certain aspects of the activity of the animal, but you cannot prohibit it. You can't make it unduly restrictive.
Right. So do you find that most of these communities that are kind of not pet friendly, are they 55 and up, or which ones are more strict?
All types. I mean, when you have the high rises along the beach, there's not a lot of areas that are conducive to having pets that are going to run around and,
or poop on the ground,
and or other things, and the barking is certainly in close quarters can be a problem. So, a lot of those communities through the years have prohibited pets, and so it becomes a little
tight
more
quarters make
difficult.
sense.
Sure.
Yeah, I could see why that would be a problem.
Yeah, the older person's communities, I don't think they're as inclined to prohibit animals. And certainly in the homeowner association, they tend not to be complete prohibition, but they might limit the size of the animal or the number of animals that
and
you
the
can
type
have.
for sure. No one wants the Rottweilers and the Pit Bulls.
Well, they don't, but under the fair housing laws, none of that matters. You can't limit size, you can't limit number, you can't limit breed, so you have to be very careful, and you need to make sure that you're not crossing any lines, because it can get very expensive if you find yourself facing a discrimination complaint.
So you're a real asset to a community when it comes to basically staying up to date with what the laws are and how that community needs to modify their laws and make sure they're in accordance with.
Absolutely. A community association is a business, and these businesses have annual budgets into the hundreds of thousands of dollars a year, possibly even into the millions. And they're operating this business, and you need independent experts to assist. You need your qualified accountants, you need management, you need legal. These are important aspects, sometimes engineering, depending on how early on, or even in ongoing situations, communities need to have reserves, so they need reserve studies periodically. Engineers are the type of people that would provide that service to them. You don't want a board member who's done construction work in another state that's retired that's now going to tell you what your reserve study should be.
When you're saying reserve studies, what are you referring to? For those who...
In condominiums, the law requires that unless the owners vote and the board offers this option to vote to waive them, they have to maintain reserves for certain aspects of the condominium, the roofs, the paving, the painting.
They have to
and-
have X number in the budget for reserves?
Correct. In addition to regular operating expenses accounted for separately and with formulas of useful life and replacement costs to determine how much per year they're going to have to set aside. And they're required to maintain these in full every year.
So I see why you need an accountant to track the money, but you need an engineer who's going to
Well,
basically...
periodically you're going to do a study to see that your numbers are accurate, that your replacement cost is right, your years of useful life is right, because that's what you're using to get to the amount you're going to be charging into reserves each year.
Yeah.
The law does allow, if the board chooses to present it, to either reduce or eliminate on an annual basis the reserves. And many communities do that.
They limit the amount.
They limit or eliminate, and then particularly some of the ones that are more older people, because they figure they're not going to be around, so they'll just deal with it by special assessment and when they need the money. And then when the special assessment comes, none of them can afford to pay that, and then it becomes problematic.
So what's your recommendation for that?
The recommendation is to have full reserves and fund them every year.
And keep the money there.
I mean, that was the
Yeah.
intent of the legislature. That's what the law required. And so that seems to be the best course of conduct to follow.
But the law's now a little more loose on that,
Well,
it
it
sounds
always had the ability to waive it because the legislature is not going to tell you everything you have to do to run your business. But in recognition of the fact that large expenditures for communities can be difficult, particularly in quick need. So rather than putting people behind the eight ball, they figured it'd make it required to have this smaller amount set aside on a regular basis.
Yeah. What I'd like to do is I'd like to go to a commercial break here in a second. I want you to give your phone number and your website so folks can contact you.
Okay, it's kbrlegal.com. kbrlegal.com is the website. Many things on the website for people to see, one of which would be a calendar of events for the continuing education that we put out, as well as resources where we have articles of topical interest that we post periodically of changes in the law or case law and things of that nature. And the phone number is 800-974-0680.
And I'd like to encourage you, if you have a question for Mr. Robert here, we're going to have you call in at 1-888-565-1470. And you're being heard today on 95.3, 103.9, 96.9, and 1470 AM.
It's almost everywhere.
I know, right? Someone was telling me they heard the show in Miami. They were, driving around and actually heard the show. So it's a beneficial show, particularly if you're, in a community and you're wanting to know what the rules and regulations are, what the law is. It's really, really educational. So when we return, we're going to come back and we're going to talk and address some questions that we have from our listeners. We'll be back after the short commercial break.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert K., Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
The other route.
And we are back with Robert K. So, Robert, we left off, we were talking a little bit about you offer these educational seminars. Can you tell us a little bit about what you have coming up?
The firm has a number of ways that we provide education to the public. We have in-house seminars that we provide in our offices. We do that in our office in Pompano Beach. We do that in our office in Palm Beach Gardens. Upcoming in February, we have a condominium board certification course on February 11th. Unfortunately, it's full, so we can't be taking any more participants in that. But on Tuesday, February 18th, we have a seminar called Covenant Enforcement for Homeowner Association and Condominiums. It runs from 6:30 to 7:30 on that evening with light snacks presented. And
Wow. The light snacks alone should get them there, right?
it should, and they're pretty good. And that's an important course. There is some CEU credits for managers as well. HOA board certification is provided on February 19th in our Palm Beach Gardens office. That one's at 3 o'clock in the afternoon till 5:30. And that one's important for getting that certification for new board members or someone who's thinking about becoming a board member in the next 12 months. You can register for the courses by going to registerkbr.com and see the various, because we do need to know who's coming. We have to make sure we have enough seating, and we have to make sure we have enough light snacks to
Exactly.
make
The light
everybody
snacks
happy.
are key.
On February 26th in Palm Beach Gardens, we have board member and officer liability insurance policies. You think you're covered? Think again. That's at 6 o'clock to 7:30 p.m. in the Palm Beach Gardens office. And you can go to our website at kbrlegal.com and look at the calendar, and that will give you the dates and topics that we're going to be having in upcoming sessions.
Isn't insurance synonymous with you're not getting covered?
Well, you're covered, but you got to make sure they don't have these little holes for you to fall into.
Yeah.
On March the 4th in Palm Beach Gardens, we have the Condominium Board Member Certification course, again an afternoon one at 3 o'clock to 5:30. And that's going to be the in-office ones. We also do our Ask the Attorney roadshow, as it were. We had one just last night in Sunrise. The next one is going to be on February the 25th in Fort Lauderdale at the Art Serve on Sunrise Boulevard at 6:45 p.m. to 8:30 p.m. Those are in a town hall format where we basically are there to answer any questions of the people that are there. They bring their questions, and we talk about them and get into some discussions on them. Other people in the audience may have similar type experiences or issues or resolutions, and so it goes relatively quickly, and it's a lot of fun to do.
Look at an important question. When you do these road shows, do you bring the light snacks?
we do bring light snacks, and once in a while we even have a sponsor that caters more of a lunch. We had one of those in January.
And so you travel all over Palm Beach County. Do you do Broward at all?
Yeah, we do. We're mostly in Broward, out of the Pompano office, and in Palm Beach Gardens is north of West Palm Beach and into Jupiter and beyond. We also get down into Marathon. We have an office in Tampa that we opened last year that's handling things up that way.
So you're everywhere in South Florida or Florida, all over Florida.
We are pretty much throughout the state, and we get involved in the legislative process as well. Michael Bender, the Bender part of K. Bender, is involved in the Florida Legislative Alliance, which is part of CAI. It's a group of people that are involved in community associations nationally. And then they have local chapters, and they're involved with lobbying in Tallahassee during the session right now to make sure that bad laws don't happen and putting forth good laws that will be good for community associations. So we're involved in that as well.
That's great. So question for you. When it comes to these people who are kind of deciding if I need to attend this workshop or that workshop, in general, are your classes geared toward property managers? Are they geared toward just the management themselves, the board, or anyone can show up, anyone who lives in an HOA community?
They're focused to board members, and then secondarily property managers, and then lastly anyone who wants to come certainly is welcome.
Okay.
But our practice primarily is representation of community associations, so they're the ones who are the target of most of what we have to offer.
Yeah, well, I think that's beneficial for our listeners to know.
Sure.
Yeah, and they could always call and ask you, right?
Absolutely.
Which is the best workshop for them to attend?
Well, a lot of them are pretty self-explanatory, and we get into, like in March we've got Navigating FHA Assistance Animal or Pet on March the 10th, which I'll be here for another radio show and talk about that one again, but at 6:30 in Pompano Beach. That goes along with the emotional support animals that we were just talking about a few minutes ago.
Are you finding a lot of resistance from the communities regarding the new law?
Well, the new regulations are actually geared to be a little more beneficial to associations, like the pendulum swinging a little bit back to association side. It made clear that people show up with a certificate that I have this a support animal. That's useless. It means nothing. It has no bearing under the law. There is no certification of emotional support animals in that fashion. You have to get proper medical information. And
so it's not like a dog that you use for seizures or...
Well, yes, those types are. And if it's an obvious type of a support animal, like for a blind person that needs a seeing eye dog, the seizure control type animal isn't as obvious, so there may be some need for documentation to support that, but mostly it's people claiming it's emotional related, and so those are the ones that get a little more difficult to address.
Right, you're getting into that gray area.
And it's definitely recommended for boards not to try and deal with it on their own. They need their attorneys to help them because they can get sucked into a pit very easily.
They can get in trouble if they're not following the law, right?
And this is one where civil fines of $10,000 can occur without really doing much. The
fines are high.
Yeah.
We're going to take a question from one of our listeners who emailed in. Her name is Joy from Boca Raton. She wanted to know, can the board change from the straight line to the pooling reserve without discussing it with the owners?
Well, apropos to what we're talking about with reserves, this is more likely a condominium question, although HOA reserves are a little bit different. In a condominium, there is the standard method of keeping reserves, the straight line, where you have a line for your roof, a line for your paving, a line for your painting in your budget, and that's specific. You're not allowed to use those funds for anything other than what you're holding them for unless you present that to the owners to vote for an alternate use.
Oh, okay.
So the pooling method takes all of your reserves and puts it into one big pile of money, but you're not supposed to fall below what you need for any particular line item. To convert from a straight line to a pooled will require a vote of the owners because there is the possibility of using funds for other purposes, so that will require a vote of the owners. Interestingly, to go from pooled to straight line, you would not need a vote of the owners because you are then setting all those numbers in place so that they're not going to change. HOAs are a little different in that the statute that required reserves is relatively recent, within the last maybe 10 years, and it doesn't provide for it automatically. It requires either the developer to have created it when they created the community, or for the owners to vote to have the statutorily protected reserves, which what we mean by is that they have to be used only for the purpose they're being held. And then you have to do the same thing every year with fully funding or the owners vote to do something less if the owners vote to create that. What many communities in the HOA type have done through the years is they just throw something they call reserves in their budget. And
it's not delegated to anything in particular?
Even if they delegate it to
general?
something in particular, they could call it road repaving. They could have a clubhouse that might need a roof one day, so they put it to that.
Right.
But unless they qualify for the statutorily protected reserve, what you've actually have is a slush fund that the board can use for anything that they may need of a bona fide nature of an association expenditure. So it's important to know the difference. Even though they're calling it a reserve, it might not really be a protected reserve. It's just a bunch of money.
I like the term slush fund.
Yeah,
just thrown in there. Julia from Hollandale asks, what can happen if the condo goes to bankruptcy due to poor management? I understand it is very expensive.
Well, yes, it is very expensive, and it's also very difficult for a community association to qualify for bankruptcy. And primarily, to qualify for protection in bankruptcy, you have to have your obligations in excess of your assets. And there is a very powerful asset that associations have, and that's their assessment power up to the value of the individual units, less the amount of encumbrances by mortgages. So depending on what your status is with regard to mortgages out there, it is possible that while you think you may qualify because you owe a lot of money, you still can assess the owners more than what you owe. So that's a hurdle that might be difficult to clear.
So you're saying that you can still get money from the owners to make up the difference, so it's not true bankruptcy?
Right. And the
I know the
bankruptcy
owners love
court,
that.
the bankruptcy court will be looking carefully at that to make sure that you actually qualify to go into the bankruptcy. And I've seen a couple associations do that through the years, but it's very easy for the owners to lose control when that happens. Last one that I observed, the association didn't want to pay certain vendors, so they ended up trying the bankruptcy route to get around it and pay pennies on the dollar, and the vendors weren't having that, and they participated in the bankruptcy.
So they were renegotiating their contract with vendors and what they owed?
They were hoping to, and the vendors have to go along with that, or they can fight it. And when they do fight it, they have to come up with a plan. And in this particular one, they came up with a payment plan, and then they never followed through with it.
But they put it in writing.
So a receiver was appointed to take over all of the affairs of the association. The receiver hired an attorney. The attorney decides to sue a bunch of people. And the next thing you know, they spent $500,000 of the association's money trying to get out from paying less than $100,000 worth of obligations. And the thing spiraled completely out of control.
Wow. They could have just paid the obligations and been done.
It would have been a lot cheaper, yes.
What a
And
waste.
then the board lost complete control, and then years later, a new group came in to operate the community.
So
But
the
the
community-
owners took it on the chin. Bankruptcy is not something I would do lightly.
Yeah, it's something that you have to really, really think about.
Yes.
What about this question? Gail from Pompano says, I'm in a co-op 719 statute with a new manager who just sent out voting for board members by proxy. The new management said they can do that. What can we do to fight it?
Well, this person seems to know that Chapter 719 has an election procedure that doesn't allow for voting for the board of directors by proxy. It has to be by an absentee ballot format, much like condominiums. So in order to address the violation, the owner can hire an attorney and try and deal with it that way. There is a division within the Department of Business and Professional Regulation, the Division of Condominiums, that has a much longer name, but that's how they're known, that encompasses cooperatives as well, and they have an enforcement section that addresses election violations. So the first step would be, and it doesn't cost the owner anything, just to contact that office in Fort Lauderdale. Go on the website of the Department of Business and Professional Regulation, check under the Division of Condominium for the enforcement section to get the contact information, and then they will get in touch with the association board and management and say, what are you doing, and maybe resolve it that way.
Yeah, peacefully. An easy way to resolve it is to get another
Now,
party involved without...
if that doesn't work out, the division could get tougher with them. They could impose fines for the failure to follow the statutory requirements, and the owners can bring legal action to compel it if that doesn't work down the road.
And our last question before we go to commercial break is Steve from Palm Beach writes, I'm a tenant in a condo and I was told I can't have a dog, but the owners are allowed to have a dog. Can they do that?
Well, in order for the board to restrict tenants, it has to be something expressed in the governing documents, the declaration of condominium in that aspect, or declaration of covenants in a homeowner community. It's not something the board could adopt by just a rule. So if the governing documents say owners can have pets, tenants cannot, then the board can do that. If they do not, then the board is acting beyond the scope of their documents, and they would not legally be entitled to do that.
I mean, that seems like that would be an agreement between his landlord and him, not...
Well, yes and no.
and not...
A lot of places, the tenant is the R word, and
The R word?
Renter.
Oh, okay.
and so,
is this a word we're not allowed to say? What is the word?
A lot of people treat that as a bad thing, even though it isn't necessarily. They don't think that tenants have the same interest in the property and the community. And I've seen many instances where they try to create additional restrictions on tenants versus owners. So
Right.
That's not that unusual. It's not regularly what's done, but yes, the owner as a landlord would be interested in restricting animals if they want to protect the property from whatever animals might do to it.
Right.
But associations have other interests as well for other owners in the common areas. So.
Right. So he needs to check his governing rules.
Got to check your governing docs.
Do you want to mind folks again about the couple of seminars you have coming up before we go to commercial break and your contact info?
Sure. It's kbrlegal.com. Go to the calendar for the upcoming events. On Tuesday, February 18th in Pompano Beach, we have covenant enforcement for HOAs and condos at 6:30 in Pompano Beach. On February 19th in Palm Beach Gardens, HOA board member certification from 3 to 5:30 p.m. It's important to register in advance for both of these so we make sure we have space for you. On February 26th in Palm Beach Gardens, board member and officer liability insurance policies. You think you're covered, think again. 6 o'clock to 7:30 p.m. And then on March the 4th in Palm Beach Gardens, a condominium board member certification from 3 to 5:30, March the 4th. KBRlegal.com and 800-974-0680.
And if you have a question for Robert Kay regarding any community association questions, the call-in number is 888-565-1470. We're going to take a short commercial break, and then we're going to come back with more questions from our listeners.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kay, Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
You are listening to the Ask the Expert Show with host Steve-O. We will be right back with more experts in the field of legal, health, financial, and home improvement. Join us every Thursday from 5 to 6 p.m. Now, get ready for more Ask the Experts.
And we are back with Robert Kay, our expert in community association law. And Robert, we're going to continue with some questions. We had a lot of questions that came in via email for you. Bunny from Boca writes, I love your show and I listen every month. So good for you,
Bunny.
Robert. I'm running for the board. Do all my maintenance payments need to be paid before I can run for the board?
Well, that's a very important issue, and I'm glad she brought it up. The answer to that is yes. In both condominiums and HOAs, there is a disqualification for candidates who are not current in monetary obligations to the association. It isn't just maintenance assessments. It could be fines. It could be reimbursement of costs. It could be late fees. It could be a number of things. You have to have a clean slate when the time comes that your name goes into nomination. So for condominiums, that happens 40 days before your election. And for HOAs, it might be the day of the election unless your documents provide for a different election procedure. But in order to qualify to run for the board, one of the disqualifiers is owing any monetary obligation. So be sure to make sure. Sometimes the management might not tell you that you have a small balance, and that could trip things up.
Yeah. What do you feel the biggest issue is facing some of these communities some of the biggest complaints or issues that you have to deal with?
Oh, it varies from time to time. The emotional support animal tends to
Be a big one?
be a big one, but then it tapers off for a bit, and then things get exciting again. There was a time, particularly in the high rises, there's an issue involving retrofitting for certain fire safety requirements, and there was some legislation to allow associations to opt out of certain mandatory requirements. But what was unintentional was it triggered a different type of retrofitting requirement that could be more expensive than the first one. So they got extensions put through, but they haven't fixed that aspect of the legislation. So hopefully before the extensions run out, that's an issue that will get resolved. But there's so many different things that can come up between construction defects, covenant violations, and every community has different issues that they deal with. So I have a difficult time pointing to one particular thing.
Because it's so varied.
Yes.
Do you find that you get more issues or complaints in one area, or it's every community in Florida has about the same number? I was just curious.
Well, we have run across communities that seem like they're more prone to it, or they've always got divisive issues going on. Right now, election season is upon us, so
is that a tense time?
It can be, particularly where you've got rival groups trying to get control of the association and looking at everything the board does under a microscope. And the procedure for the election is very specific in the statute, so any deviation or mistake can be magnified and blown out of proportion and make people crazy.
Well, what type of things can board members vote on or make decisions about besides how the money's spent?
Well, that's a big one.
Yeah, I know that's an important one, right? And assessment fees are going to be, is there usually a vote? Let's say they're going to do an assessment, or they think they need to do an assessment. Is there usually a vote that takes place with the community to say, hey, do you feel this is a fair assessment? Or the board just makes a decision, we've decided we're assessing this?
In most instances, that falls under what the board is supposed to do. There are instances when the board has to go to the membership. For example, in condominiums, the statute says that the board cannot make a material alteration or substantial improvement to the common elements except in the manner provided in the documents. And if the documents are silent, then 75% vote of the owners. So most documents will have something in there. Sometimes it'll be tied to a dollar figure or a percentage of the budget, or sometimes it just says any material alteration, which is more of a technical issue to decide if it is or it isn't, because there's case law that has looked into that and said, well, if it's maintenance versus a capital improvement, then no vote is required because the board has to maintain.
Okay.
Even if the documents say that they're supposed to vote for it.
So maintenance can be a big umbrella, though.
Maintenance can be a big umbrella. But interestingly, the Division of Condominiums has decided that if you change the color of your paint, that's a material alteration that requires a vote of the owners if the documents do so for material alterations, because they misconstrued a case from the late 80s or late 70s. That had a multicolored community go to a monotone, and they said that was a material alteration in the courts. So they said, color change, material alteration, so any color change. And that's a difficult burden. I mean, if you take your white building and paint it beige, it's not a major change, but yet it's a change. And
so they should just say any change.
But that's not what the law is.
I'm just saying, then you're covered, right?
Sure.
Do you ever have situations where you run into where the board is misusing funds and you have to advise them that, hey, you're...
Well, they don't usually tell us when they're doing that.
Well,
so.
Maybe they don't know. I don't know. Maybe there's situations where they are innocent and, they think they're following the rules, or I don't know.
If they're making mistakes of that nature innocently and it comes to our attention, certainly we would advise them. More often than not, it's the type of things where they're signing inflated contracts and getting certain kickbacks from the vendors. I hear that a lot. And that's hard to track. It's hard to discover, and it eventually catches up with a lot of people. We had a client where the president used a lot of association money at the Hard Rock Casino, and probably blew a bunch of it that way.
What was he doing with the money at the casino?
Gambling.
So, oh, but he knew that was illegal.
Yes.
Oh, okay. I thought you were giving us an example of didn't know better. I'm
that
like,
was
I'm
not
sure he knew
innocent.
better.
That was not innocent.
Okay.
But
So
it was
they called
going on
him.
for a long time.
Wow.
So the owners have to be diligent in watching what's going on, and the method of doing that is periodically looking at the association records. It's not something the board's necessarily going to show you. You have to take it on yourself.
Is there any regulation that says the board has to have their records reviewed by a third party, an independent?
Yes, every year they're supposed to create a financial statement, and depending on the gross amount of their budget will depend on the level the statute requires, but their documents may also have a standard. Many of the older documents use the word audit and may not have intended it to mean a full-blown audit, but audit's an audit. So
Right.
in those instances, if your bylaws say audit, then you got to hire a CPA and spend whatever it takes to have an actual audit every year. So where it's that in your documents, we usually suggest doing an amendment to bring it more in line with what the statute says, so it's tied more to your overall gross budget. The statute also allows, if you have a certain level of reporting, let's say you qualify for a reserve requirement, and it allows you to present to the owners an option to reduce it to a compilation every once in a while. Not every year, but
Right.
periodically, to save your money, because reviews and audits can be expensive.
Yeah, I bet. So they have to, of course, appropriate a certain amount of funds for those audits.
That should be part of the budget,
That's
yes.
the budget. And how they do annual budget meetings?
They should, yes. In condominiums, there's a statutory procedure where they have to send out the proposed budgets at least 14 days in advance, and some documents require longer. And then they have to have a meeting open to the owners to come and participate in the decision as to what to adopt. Often there's many committee meetings that go into creating the budget, depending on the size of the community. So that aspect of it should be fairly routine. Plus, you have your experience from the previous year that you usually draw on to arrive at the figures for the upcoming year, and you know if there's anything extraordinary that's happening.
Is there a standard or a regulation that says this is what the board has to disclose to you, this is where it has to be listed? What is the policy on that?
Well, again, the statutes do list for condominiums more so than homeowner associations. That's been
Okay.
around longer in the statutes, and it's more comprehensive. HOAs, because of the nature of the differences of the types of construction and communities, they don't have the same types of limitations and restrictions and requirements that the Condominium Act does. But there is a set item in the Condominium Act that lists out, these are the things your budget has to contain, assuming it's appropriate. And if it's not appropriate, well, then you wouldn't include it, because one of it would be like for management fee, that if you self-managed, you wouldn't have that.
Right. So let's take a question here from Bob from Palm Beach. He wanted to know, can a real estate agent board member be on the board or sell units?
Be on the board and sell units, right?
Well, he said or, but and or, I guess is
I
what
guess
he meant.
it wouldn't be or, but yeah, that's a common question that comes up pretty regular, because it's a perceived conflict of interest, but it really isn't, because unless he's using information that only a board member would have to further his own personal interest,
Which is hard to prove, right?
it's rare, but it could happen. And there should be full disclosure all the time to the board in an open meeting, what he does and what he's about to do, and that would resolve any type of issue of that nature. But generally speaking, while it appears to be a conflict, it typically is not.
If anything, he knows the community better and he knows the rules. He can go ahead and find the right fit for the community, right?
Unless he's buying these himself and flipping them, that's one method of improperly using your position to better your own financial house.
Give folks your website and your phone number again before we go to commercial.
It's Bender Rembaum at kbrlegal.com. You can reach us at 800-974-0680.
And they can call you and register for any of these great classes that you've been mentioning.
You can register by going to registerkbr.com, and that should have a complete listing of all the upcoming classes, and we'd be happy to have you come out.
We're going to address some additional questions that our listeners have had, but we're going to take a short commercial break.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert K., Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
Yeah. And we are back with Robert K., our expert in the community association law. And Craig from Boynton Beach had a question. He said, I live in a condo association where my roof is leaking. It is the responsibility for, I guess he meant, is it the responsibility for the association to fix my roof?
Well, again, that's going to depend on the governing documents for that particular community. Most likely, it will be the association's responsibility as in a condominium. In a homeowner association, in a townhome type setting, it might not be. You have to check your documents to see. And also, it will depend on the cause of the leak. Sometimes it may not be the roof itself. It may be something the owner did that caused it to leak, or another owner did. So in all likelihood, yes, the association should do that. It's important to also note that if it's an association responsibility and the board does not timely take care of it, the board could be facing extended damage claims for things that it otherwise wouldn't be responsible for inside the unit, such as the personal property of the owner, the furniture, wall and floor and ceiling coverings. Those are typically the owner's responsibility, but if the association through the board is negligent in addressing a water leak, that could result in the association having an extended obligation for damages.
So if you're Craig and you've checked the documents and it's it's their responsibility, you've still got to get your leak fixed, right?
Yes.
And then hope to be reimbursed.
Yes, and you may need to call an attorney to shake the trees a bit.
And I think I heard you say that it depends on your governing documents for a townhome community that the roof might not actually be covered if it's, let's say it is a community roof and there's
There
kind
are
of damage.
instances I have seen in an HOA setting that's townhomes with attached roofs and clusters where the individual roofs are the responsibility of the owners, even though they're connected to the other roofs on the same cluster. And you could have a situation where one roof has a leak, but it ends up coming into another unit because that's how water tends to go inside of buildings. And you could have an abandoned unit and it's causing a leak into a neighboring unit, and then what do you do? So the documents are very important to be reviewed and for the board to be aware of these types of situations. If they exist, then it may be beneficial to consider amending them by a vote of the owners to make the association more responsible for these common type situations.
So if you are, let's say that your document does say that you're responsible and it is leaking into your neighbor's house, well, then you're responsible for fixing the roof and fixing the damage to their place.
Well, at least for the roof, but depending on whether or not you're negligent is how your damage responsibility to your neighbor's property may flow. It may not be a strict liability thing where because it happens you're obligated to fix what's in there. Generally, in these types of settings, the documents are written so that everyone's responsible for their own. And even if there's an outside force that causes a problem.
That you're responsible. Yeah, keeps it clean, right?
Right.
Shelley from Boca writes, our association doesn't want corporate ownership. Can they do that?
Again, a documentary requirement. In order to restrict who or what can own property within your community, your governing documents, particularly the declaration of condominium or covenants, would have to contain such a restriction, because this is a restriction on the use of real property. And that's going to be recorded in the public record.
So what I'm hearing is anything is possible in the governing documents.
Well, not anything, because there are constitutionally protected areas, commonly referred to under discrimination areas, race, religion, creed, color, national origin, family.
They're blind if they have
handicap, marital status in some places, and not federally, but in
some places, marital status is a
yes. It's not a federal protection. It's more of a state or local.
Why only state or local?
Because the federal Constitution hasn't been amended that way.
I'm just surprised, because I would think they would open it to all ways that you can be discriminated against. But
well,
I think, yeah,
it's a specific list, so we have to stick with what we have.
Yeah, just curious. Julian from Palm Beach writes, what should we look for in selecting an HOA attorney? Does your firm handle insurance claims on our HOA?
That's an interesting question.
It is.
Well, what we believe you should look for is experience and competence and customer service. One of the aspects of K. Bender Rembam is the customer service aspect of it. We have live people answering the phone.
Real people?
Real people. We have a policy of responsiveness. We respond to emails and telephone calls the same day if feasible, or within the next day if we didn't get to it on the day that it came in. Say it came in at 5 o'clock, we might not get to you till the next day, but that is our general theme of how we operate. And not only do we want to be responsive, we also want to do so in a method that is understandable to the layperson. The last thing you need from your attorney is an 8-page dissertation on something that you need another attorney to translate for you into plain English. We do strive to provide understandable information to our clients. So those are important things. And then the cost-effective aspect of it is also important. With experience, an attorney that knows the field can deal with an issue likely in less amount of time than someone who isn't, who might have a lower hourly rate, but it takes 3 times as long to do the same thing. Is it better to hire the lower hourly rate or the higher one? It's the experience that is most important.
Yeah. You definitely want someone experienced. And you guys have a decent-sized organization so that you're not too big that the customer gets eaten up and lost into a funnel of different people and sent here and there, but big enough that you can, address issues and the experience.
Well, we have roughly 19 attorneys handling in 3 different offices across the board, from general day-to-day legal advice, litigation-type advice, collection of unpaid assessments, and things of that nature.
So you have a collection section as well.
Oh,
so
yes.
you help the associations not have to deal with collecting their fees.
Yes, and we do it in a way we pioneered, where we do it on a deferred basis, where we'll advance fees and costs and collect that back from the delinquent owner in most instances, if the association chooses to go that route. So the association's not out of pocket and in the collection process, unless they actually foreclose and take title to a property, which happens from time to time.
Yeah, a whole other animal.
Yes.
We have a question from Gil from New York, all the way from New York. He wants to know, do we still have to go before mediation if we are suing our condo association? Sounds like got something going on.
Well, that's an issue that is pending in the legislation right now. Currently, for condominium disputes, there's a requirement for most of them to go through a mandatory arbitration with the Division of Condominium in their arbitration section before you can take it to court. And the first step in the arbitration section is that the arbitrator is supposed to submit the matter to mediation by certified mediators that the division uses. And then if the parties cannot reach a resolution, then they both have to agree to go back to arbitration, or the matter then is dismissed and then court can come into play. That was created in 1991 to try and take some of the burden off the courts. In my opinion, that hasn't really worked out well for associations. And right now, last year there was a bill that was pending to eliminate arbitration and allow for what homeowner associations do, and that's more direct access to the courts. Homeowner associations have mandatory mediation first, but I guess we're running out of time to get into that.
Yeah, we are. So give folks your number real quick.
At K. Bender Rembam, you can reach us at 888-974-0680. Our website is kbrlegal.com. Lots of good information in there, and you should check it out.
Thank you so much for coming and educating us, and we look forward to hearing from you again next month.
All right.
So take care and be well.
Thank you.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O.
The opinions